A very warm welcome to all. Today, I, Reeya Khanna, a legal intern under Lexis and Company, am here to explain my topic combinations under the competition law. This particular video that you are watching is part 2 of this topic. Before moving with this video, let us revise what we understood in the part 1 of the video. So in the previous video, I gave you the meaning of what is competition, that it is a process of economic rivalry between different market players to attract the customers. Further, I explained that how, because of an increase in competition in the market, there was a need for a competition law, so that the mark so that an environment which facilitates fair competition is promoted, and restrainment on anti competitive behavior is done, and discouragement of market players from adopting unfair trade practice takes place. So in India, the first competition act was established in 1969, which was known as the MRTP Act 1969. Its full form is Monopolies and Restrictive Trade Practices Act 1969. So further, um, further because of the ever changing market and ever changing economy, the MRTP Act was not sufficient for the members of the country. So there was a need for amendment in this act because it had a lot of loopholes, which is why in October 1999 a Raghavan committee was formed under the chairmanship of SVS Raghavan, which gave new law or suitable amendments to the MRTP Act. So after considering the recommendations of the MRTP Act, the Parliament in December 2002 passed the Competition Act of 2002. So the main objective or the main aim of the Competition Act 2002 is to remove the impediments with the purpose of promoting competition among domestic and foreign companies as well, so that so that firms do not use anti-competitive practices in the meanwhile. So and the act regulates various forms of business combinations through Competition Commission of India. Further, I explain what is a combination, what is the meaning of combination. So combination means acquisition of control, shares or voting rights of another company, right? So in simple language, combination under competition law is merger or between two or more enterprises or two or more firms or two or more businesses into one, right? Further, I explained the threshold for combination under the Competition Law Act for a person and for a group. So now let us move on with today's video. So today we shall be understanding what are the different types of combinations under the Act, Competition Act 2002. So broadly, there are three types of combinations. First is horizontal combinations, second is vertical combinations, and third is conglomerate combinations. So moving on, horizontal combinations. So horizontal combinations involve merging of enterprises or firms which are identical to production process with substitute goods and are competitors. So horizontal combination is primarily a friendly merger between companies, although it can be a takeout of one by the other. Of course, the synergy formed by this combination enhances the business performances, financial gains, and shareholder value in the long run. The cost efficiency with the staff cutoffs lead to the increased margins of the company. However, this tends to pave way for reduced competition as a monopolist agenda emerges from the combinations of powerful enterprises, along with the unemployment that follows, which has a very drastic and adverse effect on the economy of the country. It is also bad for the consumers as the reduced competition gives the companies a higher pricing power. Therefore, these mergers are the chief focus and are often scrutinized by the competition law authority for the above reasons. Further, the second point is the vertical combinations. So vertical merging is combining of business firms which are engaged in different phases of manufacturing and distribution of a product into an interacting whole. This leads to increased competitiveness, a greater process control, wider market share, a better supply chain coordination, and decline in cost, as this sort of integration is the structuring of supply chain of company under a particular company. Further, the third type of combination is the conglomerate combination. So conglomerate combinations involve firms or enterprises in unrelated business fields. Such combinations happen when two companies that provide different services and goods are integrated into different sectors of business merged together. This sort of merger happens when the companies achieve a stronger stand in the market, both in products and services and profit management, unlike when they are individual enterprises. So conglomerate mergers can lead to an ascent in the market share synergy and cross-selling. So here diversification takes a major role and thereby reduces the risk exposure factor. So that is all for today's video. I hope you liked the topic. Thank you so much.